We're going to talk about what happens if you're married to a green card holder and you've overstayed your visa. Can you actually get your green card here in the United States or not? Let's talk about it. The big issue or problem that people encounter is this. When they've overstayed a visa in the United States and they're married to a green card holder, our government puts up this little wall and says, you cannot get over this wall for the green card. Why not? Because you've overstayed. You never continuously maintained your lawful status. If you continuously maintain your lawful status all the way up until the point when they approve you for a green card, well, you're golden. You can get your green card here through that green card holder spouse. But you've got to continuously maintain that lawful status by having another visa, not a visitor visa, because that runs out. It runs out quickly. You'll need a visa like an F student visa that will allow you to be here for a duration of your stay, as long as you're in compliance with the terms of that visa, meaning you've got to be enrolled in school. If that's the case, then you can adjust your status through your spouse who only has a green card. Or if you have another type of visa like an H-1B visa and you're in lawful status for a few years and then it's renewed and then you have another few years of lawful status, well, in that context, you'll be able to get your green card through your green card holder spouse. If you have another temporary work visa that allows you to be here lawfully for a period of time, that can work as well. So the key here is maintaining a lawful status all the way up until the point when they approve your green card application. That's how it works out for some individuals who are married to a green card holder. But for others who do not have anything but a visitor visa, and maybe they've gotten an extension of that visa and you got another 6 months, well, that 6 months expires, right? Very quickly. After that, they go out of status. Once out of status, our government says that you cannot adjust your status through the green card holder spouse. In order for you to get a green card through that person, it's incredibly lengthy and complex. But for some people, this is the only option they have. But with that lengthy process, it would include getting the I-130 approved first, of course, and then secondly, filing a waiver called the I-601A waiver to waive your unlawful presence in the United States. Thirdly, you'd need to do a visa application at the National Visa Center, the NVC. And then fourthly, you'll need to leave the country and go back to your home country for an embassy interview for the immigrant visa. As you can see, this entire process that I've just described for you, for some people, it could take 5 years because the waiver in and of itself is about 3 to 4 year wait. And then there's also a wait time for your I-130 to be approved and for your priority date to be current in order for you to move forward with the process. And guys, as I'm talking about this, it's a lot, right? There's a lot to it. Truly, the best thing to do if you're in this scenario is to wait until your green card holder spouse becomes a U.S. citizen. Once he or she becomes a U.S. citizen, everything changes. You'll be able to do adjustment of status and get your green card here through your spouse. Now, what if you're married to someone who cannot become a citizen? And friends, I meet with people in this very situation. He or she cannot become a naturalized citizen because perhaps they've tried in the past, yet the government denied them because of very serious problems on his or her record, including maybe a criminal issue. And yes, he or she did not lose the green card, but they did not overcome with naturalization. Or maybe they didn't apply for naturalization because if they applied for naturalization, it will trigger a lot of problems with immigration. So they've decided, I'm just going to stay away from immigration and hold on to my green card. And that's that. Well, if you're in a situation with a spouse like that, you'll have to go through the lengthy waiver process and go overseas to be interviewed for the green card. Not unless there's another way for you. If there's another way for you through an adult U.S. citizen child who's 21 or older, certainly you can pursue that pathway and get a green card here in the United States. For other people, if they have an employer who wants to file for him or her, the employment process is usually much faster. you can actually succeed with that process. The only issue, though, that you'll still encounter is you'll need to file that waiver. Again, 3 to 4 years wait, unfortunately. After the waiver is approved, you'll have to go to an embassy interview in your home country. These are the issues that individuals encounter who are married to a green card holder. To recap, again, it can work out for people who have another form of visa, like an F visa, student visa, H-1B visa, or another type of work visa that gives them a good amount of years here in the United States while they wait for their spouse's petition process to be finalized. Or if the spouse cannot naturalize, they would need to do the waiver and go back home for an embassy process or file their case through another relative or an employer. If you've enjoyed this video, guys, give it a thumbs up. Be sure to subscribe to my channel and hit that notification bell so that you'll be the first to get notice of these videos each week. Comment below, let me know your thoughts, and I will see you in the next one. Bye-bye.